turn my page.
May it please the court.
Go ahead.
May it please the court. My name is Jonathan Rodeback from the law firm Rooney & Rooney, the attorneys of record for Charles Fitz in this case. Respectfully request 3 minutes for a rebuttal. We're going to ask that you reverse the final judgment entered in favor of Vero Beach, that declaring that the Vero Beach ordinance number 2015-02 is valid, and to remand the matter to the lower court to enter a final judgment declaring that the ordinance is preempted by state statute insofar as it bans vacation rentals or regulates the frequency or duration of rental vacation rentals. And two, also that the Vero Beach's prohibition of what they call guest house and transient quarters is unconstitutionally vague. With respect to our first argument that the ordinance is preempted by state statute, Section 509.032 subsection 7b of the Florida statutes cannot be any clearer. It says that an ordinance cannot do three things. It cannot ban vacation rentals, it cannot regulate the frequency of vacation rentals, and it cannot regulate the duration of vacation rentals. There's one exception to that, though, and that is if the ordinance was adopted on or before June 1st, 2011. In the court below, there was no dispute about the facts in this case that the City of Vero Beach enacted ordinance number 2015-02, that it was enacted in 2015, which is after the June 1st, 2011 cutoff. There is no dispute that it bans what the city calls guest house and transient quarters. If you go directly to the definition of guest house and transient quarters in the Vero Beach Code of Ordinances, the definition includes what the state of Florida also classifies as vacation rentals, as defined in 509.242, subsection 1c. In the Vero Beach Code, a guest house and transient quarters, as defined by ordinance number 2015-02, it says that these guest house and transient quarters are not a permitted use in any residential zoning district within the City of Vero Beach limits. Since these facts are not in dispute, since this ordinance was enacted banning vacation rentals, and since it was enacted after June 1st, 2011, the state legislature has said that's not permissible. This ordinance number 2015-02, insofar as it bans these vacation rentals, is been preempted and therefore is invalid, which is why it must be remanded to the lower court and declared invalid, at least insofar as it bans the vacation rentals or regulates the frequency or duration of vacation rentals. Now, moving on to our second argument, specifically that the ban on...
Before you do that, on your first argument, isn't that, though, how we view the 2015 ordinances? If we view the 2015 ordinance as a new substantive ordinance, then obviously we would agree with you. But if the 2015 ordinance was merely a clarification of an ordinance which existed pre-June 1, 2011, then it still falls within the grandfather clause, correct?
In my opinion, no. And the reason why is because the state legislature did not say if you banned vacation rentals prior to June 1st, 2011, you can enact a new ordinance continuing that ban from June 1st, the ordinance from June 1st, 2011. It said no ordinance may ban vacation rentals, regulate its frequency of vacation rentals, or regulate the duration of vacation rentals unless that ban or unless that ordinance was adopted on or before June 1st, 2011. It didn't say anything about substantive changes or unsubstantive changes. It says simply, expressly, you cannot enact an ordinance that does it, whether you're fixing a comma, whether you're doing anything. It says do not act an ordinance that does this. And that's exactly what happened in this case. But the good news is that we don't really have to decide that in this particular case. And the reason why is because there were substantive and material changes to the definition of guest house and transient quarters as compared before the 2015 ordinance and post-2015 ordinance. For instance, if you go directly to the definition of guest house and transient quarters, it changed the definition as it existed, the definition of guest house and transient quarters existed prior to that, to now include those structures with less than 10 bedrooms. Beforehand, prior to the 2015 ordinance, it only included those structures with less than 10 rooms. You can understand that a bedroom is always a room, but a room isn't always a bedroom, and that many structures have less than 10 rooms, but almost all single-family residential structures have less than 10 bedrooms, aside from the absolute largest of mansions. More structures and more property now falls under this definition of guest house and transient quarters that did not exist until the 2015 ordinance. In fact, our client executed an affidavit to that effect. He owns 3 properties in the city of Vero Beach limits. 2 of the 3 of those properties have less than 10 rooms, but all 3 have less than 10 bedrooms. So that means prior to the 2015 ordinance, he only had 2 properties that could possibly be classified as a guest house and transient quarters. After the 2015 ordinance, all of his properties meets it. In fact, I'm not sure if there's many exceptions to that in the city of Vero Beach, because virtually all houses have less than 10 bedrooms. So that's one substantive change. Second substantive change is that prior to 2015, there was no rebuttable presumption that if you rent your property for less than 30 days, you're going to be presumed to be operating a guest house and transient quarters. That's a new restriction that was put in place pursuant to the definitions that were added in the 2015 ordinance. So if you take a look at it and you look at the definition of transient occupancy, if you rent your house for one time to somebody for less than 30 days, the city of Vero Beach assumes that you are in violation of the code by operating a guest house and transient quarters. It does not tell you how to rebut that presumption, gives you no indication if you can even rebut that presumption at all. But the point is prior to 2015, when you look at the definition of guest house and transient quarters, it didn't say anything about 30 days. It was never mentioned one time.
You're almost done with you going into your reserve time, and you haven't even hit the second issue. If you want to do a couple of quick swipes at the second issue.
Yeah, with respect to the second issue, when you go directly to the definition of guest house and transient quarters, and you read all the necessary definitions which help define what a guest house and transient quarters is, guest, transient occupancy. At its core, what a guest house and transient quarters is renting your house on a temporary basis. You're not allowed to rent a house on a temporary basis, which seems to imply that all rentals are banned in the city of Vero, because that can include rentals for 5 hours or that can include rentals for 2 years. But that's not the case, because our client got cited for renting his house for less than 30 days, and as admitted by opposing counsel in the hearing below, if you rent your property for a couple years, you can overcome this presumption that you're operating a guest house and transient quarters. It doesn't give somebody, a person of ordinary intelligence, enough direction what constitutes forbidden conduct and what constitutes permissible conduct, and for that reason.
The definitions are somewhat similar to the ones they use in the statute, aren't they?
Yes, if you look at...
So if we were to agree with you, we would be kind of indirectly saying that the statute is unconstitutional?
No, Your Honor, and the reason why is because when you look at Chapter 509 of the Florida statutes, the purpose is they want to regulate vacation rentals, and you have to get a license. So you might not be operating a guest house and transient quarters, or in the context of the state statute, whether you're trying or actually rent out this property, we want you to get a license because it's held out to the general public on a regular basis. In the state, in the underlying ordinance, what it's saying, if you rent your property for one time less than 30 days, you're presumed to be operating this guest house and transient quarters, but it doesn't say you can rent your property for greater than 30 days.
Do you think it would be more clear if it didn't have any time period at all and didn't have any opportunity to rebut the presumption?
I don't think so. In fact, I think the presumption was created for the fact that they're trying to say you can't rent your property for less than 30 days, but they're not coming out and saying it.
You want to save your 30 seconds?
Yes, I do, Your Honor. Thank you.
May it please the court, my name is John Frost, and I have the privilege of representing the city of Vero Beach. Your Honor, to your observation, I think it would be, you would be declaring 509 unconstitutional because it is almost the same identical language that is in 509, which is kind of interesting because Mr. Fitz said he was knowledgeable about 509 and what it contained because he had to get a license. So he knew that what the restrictions were in what he had. And Judge Gerber, to your observation, this is exactly what the judge found below. That what the statute says, and it wasn't pointed out real well, is it said that 509-0327B, this paragraph does not apply to any local law, ordinance, or regulation adopted on or before June 1st, 2011. It doesn't apply. The city of Vero Beach has been regulating guest quarters and transit quarters since 1977. It's been in their ordinances that you can't have those types of facilities in residential areas. It's been identified that they cannot be in residential areas. And so what's happened here is that, and the judge in going through his final judgment, which was a result of he already issued an order on plaintiff's motion for summary judgment, and he addressed each of those issues, and he addressed it by saying the city has been since 1977 dealing with those, and he found that there was, he said in ordinance 1977-1334, the use was not a permitted land use in any zoning district. And that's talking about the same definition that guest houses and transit quarters. So in 1977, they addressed it. They changed the version in 1986 and specifically defined that guest houses, transit quarters, any structure including converted dwellings in which less than 10 rooms, will or without meals, are rented or otherwise provided for compensation to transients for their temporary care and lodging. The 10 room issue, 10 room versus bedroom, was not raised in his pleadings, and the judge below said, you've not raised it, you can't argue it. But even addressing that, the fact is that the rooms is modified by lodging. So therefore, when you're saying you can have 10 rooms for lodging, you're not saying 10 rooms including a bathroom, a kitchen, a porch, or whatever you have. So there has been no change, and the ordinance has been in existence for a significant period of time. And that's what the judge found in the lower court. He said these are the same statutes or same ordinances. There hadn't been any substantive change. And so the law says this paragraph does not apply to any local law, ordinance, or regulation adopted on or before June 1st, 2011. There's no dispute that the city of Vero Beach had these ordinances dealing with the same issue since 1977. So that the law, that what he found is that specifically addressing those issues, Judge Kennerak said that there was no substantive change, and that the request for declaratory judgment, count 1 of plaintiff's second amendment complaint, that ordinance number 2015-02 is preempted by section 509-053 Florida statutes, is answered in the negative, as ordinance number 2015-02 is not preempted, that it was not changing anything. And then he said judgment as to count 3, that he had 2 other counts which they argued but they did not appeal. The request for declaratory judgment, count 3 of plaintiff's second amendment complaint, that ordinance 2015 is unconstitutionally vague, is answered in the negative, as ordinance 2015-02 is not unconstitutionally vague. And so what he found is, under the Dunn case and other cases in other jurisdictions, the definition of temporary, they found that temporary is not so vague You can go to Webster's, you can go to Black's and get the definition for temporary. As a matter of fact, the appellant in their initial argument, one of their memorandums, had gone to Black to get what temporary means. And the Dunn case out of Georgia, other cases have specifically found the use of the term, one of them was temporary domicile, was not unconstitutionally vague, and have found that those words did not make the statutes they were looking at unconstitutional. And in this case, you've been cited no case by the appellant that says temporary is a word that leads to unconstitutionality. So I would submit that that is an area in which the law is fairly clear, and Judge Canterac was completely accurate. He goes through the whole observation of answering the question about was there any change in the statute. There wasn't. He found that the preemptive part that was argued below about the presumption was not a substantive change to the definition. It was an evidentiary matter that could be decided. And if you came in and said, hey, I have a lease here for 25 years, that may rebut that presumption.
Well, I gather that your opponent's position on the first issue is that, as he said, if there was a change in the comma, if you adopt a new ordinance, that ordinance cannot be enforced. Now, isn't that the face of the statute? Isn't that the interpretation? That it says it won't apply to any ordinance adopted after this date.
But then to reconcile that, Your Honor, you have to look at this paragraph does not apply to any local law, ordinance, or regulation adopted on or before June 1st, 2001. And the statute we're talking, or the definition we're talking here, was adopted long before that.
Okay, so this one was not a replace and a repeal and replace, as we hear so often.
And that's what the judge found. It wasn't. There was no substantive change. You changed bedrooms to bed, and that was it. And you changed an and in there. But he said there's no substantive change. It's the same thing you had before. You have it now. And the statute allows you to do that because that's why they have it in there. Now, if we entered something new, it would be a different story. But what we're saying is, hey, if you change a comma, that's not what this was intended to do. What it was intended to do was to not allow additional cities to put in new ordinances, new regulations on vacation rentals. That's not what happened here. What happened here is that they cleaned it up and didn't make any changes. And that, so I think.
What was the intention of cleaning it up? What was there? What was necessary to be addressed to clean it up?
Some was grammatical. The and, for instance, was grammatical. It was clear. I don't think there's as the judge said, there's no substantive change at all. And that's what they did. And they put bedrooms instead of rooms. But it's modified by lodging. I don't think they needed to do that, but they did. But they weren't making substantive changes. They've been dealing with this issue since 1977 on these types. And Mr. Fitz bought his property knowing these were on the books. And so where we are is that there wasn't any substantive change, as the judge found. And this is kind of a mixed bag on review. The questions of fact, you look at as to whether or not he applied the law to those facts. But in this case, he went ahead and found, he applied the law that he found.
I appreciate your response that there was, in your opinion, no reason or need to clean it up. But because this was decided at a summary judgment stage, I think the only affidavit that was filed in the case was by the appellant, that we don't know as a factual matter, by affidavit or otherwise, from the city, well, this was the purpose of why we cleaned it up. This was grammatical. This was making it gender neutral. We don't know why they did it. All we can do is accept, based on what you're saying, that the trial court's conclusions that it was nothing more than non-material revision.
Well, everybody agreed below that there were no material facts and issue, both sides. So there was no material facts and issues as it was. The affidavit was not filed at the summary judgment hearing. It was filed after the summary judgment hearing. But when we file for a motion to have a judgment entered, because it would be wasted judicial time to come to here and say, okay, we'll put on the exact same evidence. But the facts are not in dispute. And I don't think there was any necessity for the judge to have an affidavit from our side to say, hey, here's why we cleaned it up. Thank you. I think I'm out of time.
Yes, you are.
Extremely briefly, Your Honor. Just addressing the rooms versus bedrooms issues and that you wouldn't rent out a bathroom or something like that because that's not for lodging. The definition of guest house and transient quarter says for transients for their temporary care and lodging. If you rent out your house, you're also going to rent out the bathroom as well. You're not going to provide or deprive somebody of use of that restroom, so that would be included in the rent as well. So that's why bathrooms are also rented out. Regarding Judge Cantarac pertaining to the no substantive changes, that wasn't at issue at the summary judgment stage. All that was issue is whether a declaration was necessary. Judge Cantarac determined that there was no substantive changes but didn't take any evidence on that issue. We didn't know that the substantive, whether there had to be substantive change until after the final judgment was entered. And
And did you ever ask him to do that?
yes, we did a motion for reconsideration as soon as the summary judgment denying our declaratory relief was entered, stating about all the substantive changes and said, you know, you determined a factual issue at the summary judgment stage that wasn't presented to the court, and that got denied.
Okay, thank
Thank
you
you.
very much. The last case of the morning is Nicolaitis